Hi everybody, this is Judge Jerry Simoneaux in Harris County Probate Court Number 1, and I'm here to give you some pro tips in heirships. These are just some tips to make sure that you have the most successful hearing that you can and that you get before the court as soon as possible. We're going to start out with decoding the code. One of the things that we need to do is get rid of the mystique with the estates code. And believe it or not, the estates code is kind of separated out into discernible categories. One, you have notice statutes, you have pleading statutes, proof statutes, what you do at the hearing, and what goes in the order. And this is true throughout the estates code. It's not just for the heirships, but it's also in administrations, probate of wills, and the guardianship section of the estates code really has some great sections on notice, pleadings, proof, and order. So let's get started with notice first. The general notice statutes are in Texas Estates Code 51.001, and the general rule is the court gets to determine what requires notice if there's no specific statute on point. So this is one of the things that you may want to check with the courts to see if the court require extra notice in any particular circumstance. Probate Court Number 1 mostly does not require any extra notice. If it's in the statute, that's all that's required. Methods of service are personal service, service by mail, service by posting, and service by publication. These sections tell you what this is about, how it's done. The return and proof of service are in 51.101 and 104. You hear about the return date all the time. That's where you find out information about it. And who can waive and how is in 51.201. Now these are general statutes. We have more specific statutes when you're talking about heirships. In heirships, when you have known persons, you have to serve personal citation by mail on each person who is 12 years of age or older, or on the parent, the conservator, or the guardian of the person who is under 12 years of age. Service by publication is done on everybody who is unknown, and if you have an heirship, you start out with the premise that there may be unknown heirs. And so every heirship has citation by publication. It has to be done in a newspaper of general circulation. New rule on that, it doesn't have to be in the county where the hearing is taking place. It just has to be in a newspaper of general circulation, and your clerk usually will help you with that. And it has to be published through the Office of Court Administration. The clerk will automatically send a citation to the Office of Court Administration, and the Office of Court Administration will send back a return. The return date on service by publication is 10 days plus a Monday. This is where you have to combine statutes to figure that all out, and you see where I've done that. Citation by posting only applies if citation by publication does not apply, and in heirships, it's all citation by publication. And then you have also, these are the specific waiver statutes for heirships. Anyone under 12, then it has a parent, a conservator, a guardian, an attorney ad litem, or a guardian ad litem can waive service of citation. Now, this is not the attorney ad litem who is appointed to represent unknown heirs. This would be a specific case where an attorney ad litem is appointed to represent someone who is under the age of 12 for some reason. Then that attorney ad litem can waive citation. So don't ask the attorney ad litem who is charged with representing unknown heirs to waive citation. They cannot do that. Anyone who is age 12 to 17 cannot waive service. They must be served with citation. And anyone 18 years of age or older can waive citation. Now here's what's important. This is what I need you to know. That 202.057 affidavit that tells the court who's been served and why, and how rather, needs to be on file before your hearing, or at least on the day of your hearing, before I can sign an order. Otherwise, if that 202 affidavit is not on file, I cannot sign an order in heirships. Notice in administrations is in 303 of the code, and you have citation on applications. This is what the clerk issues, and it's on all persons. It's done by posting. And again, there's that posting statute if you want to go back and refer to that. Here in administrations, the court cannot sign an order appointing an administrator unless citation by posting has occurred first. This is why some people get calls saying that we have not seen posting on this, you've not requested posting on this, or you've not requested citation on this, and we can't go forward. This is one of the problems that you see. Pleadings. Let's talk about the pleading statutes. In airships, they're generally 202.001 through .009. I want you to go and read all of those. Right after this video, go and read all of those because they give you different circumstances where you have to plead certain things. But here's the general statute. .005 says, this is what you need to put in an application for proceeding to declare heirship. It's all there already. Go back to your forms. Compare your forms to the statute. Take out anything that is not in the statute because it's extraneous, it's unnecessary. Don't use those old forms unless you have first updated them by looking at the law. If you don't have forms, the statute right here, you cut and paste it and stick it in and fill in the blanks, you're good to go. It's as easy as that. The application has to be supported by the affidavit of each applicant. So this is a verified application verified by the applicant or applicants, not the attorney, unless the attorney happens to also be the applicant. The contents of an application for administration are in 301.052. Again, this is everything you need to create a perfect application for administration. Read those accompanying statutes, though, in case there's a little something different that about your particular situation, just so that you make sure you include everything. Proof. What do you do at the hearing? Well, for proof of heirships, prove up the facts that you've pled in your application. So we've looked at the application. We know it goes in the application. You know you have to prove those things up. Those are the questions that you ask. And of course, you ask about family history to prove up who the heirs are. The testimony that you take from your witnesses has to be reduced to writing and subscribed and sworn to by those witnesses. Now, the witnesses have to be disinterested and credible. Not just disinterested, okay? They have to be disinterested and credible. What that means is if you have an heir, someone you want to prove is an heir, and they're bringing in their husband and their daughter, those two people are related by 1 degree of consanguinity. And even though they are technically not interested, they're not going to inherit from the deceased person, they have a potential interest to make sure that their wife or their mother gets, or whatever the spouse is, whoever the spouse is, that the spouse and the parent get as much as they can. And so there could be a situation that one could imagine where the heir wants to leave out a child from a previous marriage or a child from outside the marriage. And they're only having their spouse and their child testify, their adult child testify as to who the heirs are. So that could be a potential credibility issue, even though they are technically disinterested. That's why courts kind of don't like you to do that. If you're going to have someone who is related within 1 degree of consanguinity, try to have the second witness be someone who is completely unrelated. And it doesn't mean that you can't do spouse and adult child. You can, but know that there could be a credibility issue going forward. Not just putting it out there for you. There are situations where you can only find one person who is both disinterested and credible, but you have to put on some testimony of due diligence why you couldn't find somebody. And this has happened before. This is not, it's uncommon, but it's not something that's never happened. Somebody who has outlived all of their friends, all of their relatives, they've been alone all of their lives, and there was only a caregiver, for example, or maybe a neighbor who knew this person well enough to be able to give testimony about their family history. And in that situation, then the courts under this statute can't allow just one person to testify. General proof requirements for an administration is just five things that you've got to prove other than all the elements that you've pled for in your application. Remember, put those forth. But these things are the general proof requirements: that the person's dead, 4 years have not elapsed with certain exceptions, the court has jurisdiction and venue, and I've put chapters 32 and 33 for jurisdiction and venue, that citation has been served and returned, see that citation statute again, and that the person seeking letters is not disqualified, and disqualifications are in 304.003. So take a look at those disqualifications and go over them with your client. It's not just Have you been convicted of a felony? It could be other things. So just make sure you look at that. The order. What goes in the order? Again, orders and heirships. Put the order in the order, the things that you put forward as your proof in the hearing that relate back to your application. So your application alleged certain facts. You put on proof of those facts in your hearing, and now the order has to include that. But the required statements in an heirship are the names of the heirs and their respective shares. That's the important part. Determination of intestate and the determination of intestate succession. Now I want you to take a look at 201 of the statute. The determination of intestate succession is something that trumps everybody up. Not everybody, trumps some people up from time to time. So here are some sample charts. The first one is John Doe is the surviving spouse. His wife has unfortunately died. He has 2 children, Debbie and John Jr. And this is how we separate it out. We have share of separate personal property, share of separate real property, and share of decedent's community property. So John, as a surviving spouse, gets all of the decedent's community property. So don't put 50% in there. Put all of the decedent's community property, the decedent's community property. Debbie and John get none of the decedent's community property. Now, what if you have a John Doe is married to the decedent, but the decedent had a daughter from a prior marriage. So this is not of the same marriage between John and his wife. This Debbie had a different father. So in this case, take a look at the share of decedent's community property. John Doe gets none of the decedent's community property. He retains his community share, but he gets none. So don't put 50% there either. He's not getting 50% of the community property. He's getting none of the decedent's community property. That's kind of the nuance there. And of course, Debbie gets all of her mother's community property in this situation. If you would like to see this in chart form, rather than reading it in the statute, Probate Court 1 has this chart. Let me move over. So we have these 2 charts right here that you see. And you can go to our website, just Google Harris County Probate Court 1 and look for Texas Descent and Distribution Chart. And this will help lay it out for you visually. Orders and administrations. Again, the matters that are alleged in the application, the proof that you put on in your hearing, put those in your order. But the order granting letters has to have these findings, that there's a necessity as determined by the court for an administration, and then there are certain enumerated reasons, other reasons for necessity. And it's usually that, there's property that needs to be gathered and distributed. There's real property, for example. There are debts of the estate that need to be paid. Those kinds of things are a necessity for administration. And in the order granting the letters, this is the same order here, you have to have the name of the decedent, the amount of the bond if there's a bond, and if an appraiser is requested. I have never seen an appraiser requested in an application for administration. And the court does not sua sponte appoint appraisers, so you don't have to say, please waive appraisers. We don't appoint appraisers unless you ask for them. So that's important to know. You don't have to say waive appraisers. We don't do it automatically. All right, so what to do and when. So what you need to do is, this is just a tip. This is not the law. My tip is to file a separate application for heirship and a separate application for the appointment of an administrator, and then file your proposed orders for each of those. And there's a reason for that. Remember the citation statutes, the notice statutes? Notice statutes are different for heirships than they are for administration. So if you have a combined application, the problem is that you don't request all the notice that's required of both. And so one or the other is going to trump the whole thing. It's not going to work. The other reason is that sometimes something might happen and you might be able to go forward on an heirship but not the administration, or you may not be able to go forward on the heirship, but you can go forward on a dependent administration. So you may be able to do one or the other, but not both. And if that's true, then you only have that one application or the two separate applications rather, and two separate orders, and we can work with you at hearing. For in-person hearings, when we return to in-person hearings, then you need to file the following unexecuted documents. Do not execute these ahead of the hearing if you're coming to the court in person. The orders, the oath, and the written testimony of those who are giving testimony as a witness. Those are unexecuted. And the reason why you file them as unexecuted documents is because the clerk will have them in the system when you arrive for your in-person hearing, and you and your client will be able to sign digitally using a digital signing pad, and there's no paper exchange. So you don't have to, this is just like bringing paper to the court, except that you're pushing a digital file to the court ahead of time. If you're doing a remote hearing on Zoom, for example, and we will have remote hearings long after COVID, then I need you to file the executed documents, the executed orders, oath, and written testimony after the hearing. You do not need to file any unexecuted documents in an heirship or an administration ahead of time. Okay, this is for remote only. For remote only, don't file those unexecuted documents. We're not going to use them. File only the executed documents immediately following the hearing. Okay. And some common mistakes. There are a bunch, unfortunately. So there's common mistakes in notice, common mistakes in applications, and common mistakes in orders. So let's take a look at those in succession. Common mistakes in notice. The 202 affidavit that's required for heirships is not in compliance because it does not include everyone who is entitled to citation. It doesn't say how notice was given to each person, and it doesn't say why notice was not given. For example, somebody filed a waiver and didn't need to give notice. Sometimes there is a failure to serve citation on a minor 12 years or older because maybe somebody didn't think that a citation on a minor 12 years of age or older needed to have citation. I don't know why. Getting waivers from the minor apparent for minors 12 years of age or older. Remember, if they're between 12 and 17, they cannot waive, and nobody can waive for them. If they're under 12, then their parent or guardian can waive for them, or even the attorney ad litem or guardian ad litem, for example. Failure to obtain a return of citation from the OCA. I have OCR there, that's a mistake. It's the Office of Court Administration. Just wait for that citation to be returned from the Office of Court Administration. If you don't see it, call the clerk and find out. Failure to serve the citation by certified mail, return receipt requested via the clerk for heirs. So the clerk issues citation and the clerk mails that citation. You have to make sure that the clerk does. That's what you're asking for. You're asking the clerk for citation on these heirs who you're required to serve citation on. Make sure you ask for the right thing. And the clerk will do what you ask, but the clerk's not going to, if you don't ask, you're not going to get it. Failure to personally serve heirs who are residing in the state by constable. So when you're serving, you have to serve by constable in an heirship. Failure to request citation by publication. This is in an heirship. You have unknown people, so you got to serve unknown people by publication. You have to ask for that. And again, in the case of a combined application for heirship and independent administration or dependent administration, the failure to request some kind of notice or some kind of citation that's required for either one or the other. Failure to waive further notice and incorrect waivers or consents. Okay, so a waiver is a waiver of notice or a waiver of citation. It says that I'm presenting myself to the court and I don't need notice, I don't need citation, further notice or citation or further notice in this. Consent is different. Consent is under 401 of the Estates Code, and that's what you need to create an independent administration. And be careful of those consents too, because you have to say you have to say three things if you want these three things. I'm consenting to an independent administration. I'm consenting to no bond, or if you want a bond, then leave that part out. And I'm designating person X to be the administrator. So those three things should be in there. I'm consenting to an independent administration. I'm consenting to bond or no bond, and I'm designating so-and-so as the independent administrator. Those things have to be in that consent. So mistakes in applications. Failure to include the age of minor children. Okay, so if you have someone who is a minor, let us know how old they are, because if they're under 12, then a parent or guardian can waive notice or citation. If they're between the ages of 12 and 17, then we know that they need to receive citation served on them. That's why we need the ages of minors. If they're an adult, I don't need to know their age. You can just put adult on there. An application is not verified by the applicant. We went over that just a little bit ago. Mistakes in orders is, in heirship orders, they're a bunch. And this causes us to have to do a lot of corrections and help you out with these. Not including both community and separate property. Just include both community and separate property. Even if the person was divorced or predeceased by a spouse, it doesn't hurt to include the community and separate share, although including community for that might be a little bit wonky. We did have a case where people came back years later and said that there was some community property that was still out there, and an heir was entitled to it, but it was not included because of a prior problem with a partition in a divorce. It was a very unusual case, but that would have been a case where it would have been nice to say, well, these heirs are entitled to what community and what property, what separate property. Not using fractions. Don't use decimals. If you have 0.33 or 33%, somebody's going to have to get 34%, and that doesn't make sense. Combining fractions and percentages, so one person gets 1/4 and the other person gets 25%, that equals 50%. Well, that actually works out, but what if somebody got 1/3 and somebody got 33 and a 0.3%? That doesn't work out. Improper fractions, 1/3 and 2/9 do not equal 9/9 or 3/3. Improper addition or division of fractions, so if there are 5 people and they're each getting 1/3 each, that's 5/3. Not sure how you can split up a pie into 5/3. There are only there are only 3/3 in a pie. Where are the other 2 pieces coming from? So, and I know this is sometimes oversight, and it could be just importing from another application, but be careful and just use fractions. Failure to include the estate of a post-deceased heir. So this confuses people. So if Jane dies and her son John dies after her, then what we need to do is we need to include John's estate as an heir, not John's heirs as an heir. So if John had 2 children, we're not going to say John's 2 children. We're going to have John was alive when Jane died. John just happened to die after. So he would have been an heir. He was alive at the time Jane died. So his estate is now the heir. Now, if John had died before Jane, so Jane dies, but John died before Jane, then Jane's heirs would then be the children of John, because they will have been the actual heir on the date of Jane's death plus 120 hours. So that's the only time that we'll do John's children plus other children of Jane. You can't piggyback, though, an heirship. If John died after Jane, you can't piggyback an heirship and just automatically declare John's children as the heirs. It's John's estate as the heir. That's the no piggyback rule. That's a real thing. All right, skipping lines of descent. So Jane dies, and we show that her great-great-niece is the only heir. How did we get to great-great-niece? If you could show on there that Jane had no children, she had a sister, her sister had children, these children died, and blah, blah, blah. And that's how we got down to great-great-niece. That would help out. All right, so those are the common mistakes. Let's talk about the staff who are supporting you. Again, I want you to have a successful hearing. I want you to look good when you're in court and in front of your colleagues and in front of your client. That's the goal. But the court staff cannot give you legal advice. I do have staff attorneys, but they're not here for the public or for other attorneys. They're here for me. The staff attorneys advise me on legal issues that I test them in with. But what our court coordinators and staff attorneys can do, though, is they can point out what is deficient and give you code provisions to cure, point you in the right direction so that you can find the cure for yourself. They can assist you with procedural issues, but not substantive legal matters. They can assist you with local rules, help point out what the local rules are. They can even talk to you about what the judge's preferences are, because I know there are 4 probate courts and not all of us have the same mode of doing things, same preferences. So that is perfectly a fine question to call and ask. What does the judge prefer in situation X? And if there's a novel issue that you've never run across, we probably have seen that already. That's okay to call the court on and say, hey, I've never seen this. What in general do we need to do in this particular situation? And in general, we'll give you the answer, but we're not going to give you legal advice. The attorney's job, the staff attorney's job is, the attorney's job, your job, is to review the applicable law and find the actual answer for yourself. We'll point you to it. We'll try to help you out with it. We'll tell you what, to the extent that we can, what you need to do to correct it, but we can't give you legal advice. You have to look it up yourself. We do not review applications in advance of filing them. That happens an awful lot. So please do not submit applications for review ahead of filing. We don't even know if it's going to fall in probate court 1. We don't know which court it's going to fall in, number 1. But number 2, the staff simply doesn't have time to do that. I can tell you right now that my staff put in every bit of 8 hours. They probably put in 10 hours of work in those 8 hours already as it is. And that's, I have amazing dedicated staff, but we don't have time to review your applications prior to, so don't do that. Other than that, we're here to help you. We want you to have a successful hearing, and I look forward to seeing you with your perfect application and your perfect orders in court very soon. Thank you very much.